So I've been a member of the Connecticut Bar since 2003. So 15 years continuously as a litigator in this state for one of the most well-respected firms, big firms in our state. Before that, I did 3 years at one of the biggest firms in the world in New York City. So almost 20 years of practice as a commercial litigator, uninterrupted. That's what I do to make a living. That's how I pay the bills and feed my family. And it's important to note also that on the legislative side that I'm the House Chairman of the Judiciary Committee, which means I have overall responsibility for our state's legal system.
Including this quote-unquote Weisswitz rule, which, for years has been talked about since then in terms of potentially changing the statute. I guess talk a little bit about the work that's been done in that committee in order to, in the discussions that have taken place over this specific statute.
So what's absurd and frankly offensive is that I'm, as the House Chairman of the Judiciary Committee, I have primary responsibility for that statute that says that you have to have 10 years of active practice at the bar of this state. And I've worked hard. I think we've debated changes to that bill a couple of times. It hasn't come out of that committee. But I live with this statute. And you better believe that as soon as we heard that George Jepsen was not going to run again, I double, triple, quadruple checked with a number of lawyers and legal authorities just to make sure that in their view I was good, because I was confident, I am confident, and I'm ready to stand toe-to-toe with any lawyer in any courtroom anywhere in the country, not just in Connecticut.
And I gotta believe that the state Democratic Party, after everything they went through 8 years ago, also had their own lawyers looking at it independently of you to tell you whether or not you'd be okay.
I've actually talked to lawyers affiliated with the state party, and this was peddled around as a smear campaign on the floor of the convention, and the delegates rejected it. 64% of the delegates of the state convention voted for me, even after hearing these whispers and rumors that have no basis, because they know it's nonsense.
And describe the work that you do at your firm. It's
Sure.
It's not like the real estate attorney who's working in a small office there at home, or covering DUI cases. I mean, describe the work that your firm does.
So I work at a big firm, and in a big firm litigation practice, it's major civil cases, usually teams of lawyers, almost always teams of lawyers. You don't do it by yourself. Often with other law firms partnered with you, and they're high stakes litigation. These cases take years and years to develop, and they rarely go to trial. When they do go to trial, they rarely go to verdict. But all along the way, these cases are heavily litigated, from depositions to motions to dismiss to motions for a summary judgment to trials to verdict. And that's the sort of work I've done for years and years at a big firm, at Findix & Hurling, and before that at Simpson Thacher and Bartlett in the city. And what distinguishes me from the other candidates in this race is I'm the only candidate with that experience. I'm the only candidate with deep, almost 20 years of experience litigating major civil cases, multi-jurisdictional, state and federal, high stakes. And frankly, none of the other Democratic candidates and the Republican nominee, they don't have that experience, and that's just a fact.
They may have, Susan Hatfield, say on the Republican side, has been a prosecutor.
She's a prosecutor.
Right?
That's
so
not what
she has that experience in terms of courtroom experience, right? Matty was a U.S. attorney. He has that experience. But as you say, it's civil cases. If you're going to be an attorney general, you're not doing criminal. You're doing civil cases, which is similar to the type of stuff that you've been working on.
Yes, the Attorney General it's not a military designation. Yeah. The Attorney General is the general attorney for the state, and you're doing civil cases. Let's just be clear about what the Attorney General is and is not. The Attorney General is the general attorney for the state, civil jurisdiction almost exclusively. There's a small pocket for home improvement contractors. But the Attorney General is not a prosecutor. That's a common misunderstanding. And so frankly, I don't think the Republican nominee or anybody who's been a prosecutor has any experience doing what the Attorney General does. I've represented clients. That's what the Supreme Court demands in the decision that it wrote in the Weisswitz decision. And it's my primary means of making a living. I've represented, maybe hundreds of clients in almost 400 matters I counted. Dozens of cases in state court in Connecticut alone, dozens of cases in federal court, and dozens of cases outside of the state. We litigated a major commercial dispute that was an international dispute in New York Supreme Court, and that went to judgment, and I was part of that trial team. So, for almost 20 years, I've made a living as a civil litigator at one of the most well-respected big firms in our state, doing all the work that trial litigators do: depositions, motions to dismiss, motions for summary judgment, applications for prejudgment remedy. That's a big thing that we do here in Connecticut, and that's often considered the trial, because that often, ends the matter, and then the parties have to come to an agreement and settle. And that can include witnesses, lots of written pleadings and briefings, and this is what I do every day.
So you saw the McKean blog, and some of the, I know Christine Stewart wrote an article kind of talking about everybody a while back.
Sure.
We're questioning whether one portion of that Bysowitz case that talks about having experience trying cases.
Yes.
And that's one of the things that Ryan brings up. I guess how, Ryan defines a trial as, opening and closing arguments, questioning witnesses, the television trial, so to speak, that we think of, Perry Mason, O.J. Simpson, right? Do you have experience doing that type of trying cases in a courtroom in front of a judge and in front of a jury?
Yes, that's just not reality, by the way. If you go to any courthouse here in Connecticut, federal or state, and you ask a lawyer, what are you doing today? And they say, we're going to trial. That could mean a trial to verdict. That could mean a major summary judgment motion. That could mean an application for a prejudgment remedy. It means a major hearing where there can be witnesses, where there's opposing counsel, where you're going back and forth, where you're trying to get a judge to make a ruling. And the fact is, I've done that dozens and dozens of times in dozens and dozens of cases. So, for example, you ask about trials and cases in which I played a major role, cases that are heavily litigated with significant trial proceedings. I can think of 10, recent and pending cases now. For example,
I would say, what are some of the cases? That's one of the things Ryan said in that post.
So,
what are the cases?
For example, I can think of a case pending now in front of Judge Thompson. I represent a railroad. Significant trial proceedings. That case may settle. Yeah. 3 cases I'm doing now in a mix of state and federal court. I appeared before Judge Bellis in Bridgeport State Court representing a major supermarket chain. That's 4 right there. A trial I did to verdict and judgment in front of Judge Weiss in New Britain Superior Court. That was in 2016. Okay. 3 cases in front of Judge Edgerton. 1 case in which we litigated and tried over a couple of years, a significant prejudgment remedy. That case ultimately did settle, but witnesses, lots of argument. I was part of that trial team. And let me add also 2 more. I haven't gotten up to 10 yet, but in Judge Edgerton's courtroom, I tried a case to verdict. Gave the opening in that case, for example. Remember it very well. And another case.
Which case was that?
It was a Chardavoine case, actually, that has been written about some. Sure. 2 other cases where I was lead counsel, one in front of Judge Ecker in New Haven, who's now Justice Ecker. That case actually led to not a trial, but a mediation, which is often a substitute for trial. Okay. And I did that in front of Judge Dranginis. Yeah. Mediated another case in front of Judge Holtzberg. Yeah. So, dozens and dozens of cases, tons of experience as a litigator, as a trial attorney, and there's just no question that under the standards set forth by the court in the Bysowitz decision, the 3 prongs, some litigation experience, that you do it for a living, and that you represent clients, hundreds of clients, there's just no question that I meet the standard.
So obviously, in the one of the big things you're talking about in the campaign is challenging President Trump. And that, the cases where you challenge the president, you could end up at the U.S. Supreme Court. Are you confident in your experience in making that argument to a jury, to a judge, to a Supreme Court justices, that you do have that experience in that portion of what this job would be?
Very confident, because I've done it in front of state and federal court judges here in this state. I mentioned Judge Edgerton, I mentioned Judge Bellis, I mentioned Judge Weiss and Justice Ecker. And on top of that, I will note that the people of the state have seen me on my feet over and over again, more than the other candidates, because as chair of the Judiciary Committee, I'm personally responsible for the state's gun laws, for example. Wrote and passed the domestic violence gun law and also the bump stock ban this year. Defended the Trust Act, which provides sanctuary to immigrants here in Connecticut. All of that on my feet, on television, making arguments, taking fire from the right-wing hate machine. And people can see that. They can see that on video. I'd be happy to, well, you've seen it, George. You've covered it. And what's really...
You've also gotten some of that hate.
Reporter for it. No, you have too, actually. We had an episode last week. We had an episode last week. And what's really disappointing about this is that we're not talking about the issues. We're not talking about how I'm going to stand up to Donald Trump and create a civil rights division, how we're going to strengthen consumer protection and go after the addiction industry. And instead, 5 weeks out, we've devolved into a orchestrated smear campaign by, desperate candidates looking for attention. And, we don't have to go down that road. The president does enough negative campaigning and public smearing to take care of the rest of us. So we don't need to go the way that Donald Trump has.
One of the things, looking through the research, when I read the CT News article,
sure.
News Junkie article, they mentioned that New Britain case.
Yeah.
Now that did go to trial. So was that incorrect in the article?
Sure, it did. It did, and I got a judgment. And then the company declared bankruptcy, and it was hard to collect on that judgment. And I represented the company in the bankruptcy in Iowa. Yeah. And I should say that is a manufacturing company here in Newington, Connecticut. Yeah. And so I've represented Connecticut companies in significant litigation. That was more than $1 million judgment.
Like you said, some of the things that Ryan had talked about, I want to stick to what
sure.
you're saying. So you've been able to question witnesses in front of a jury in multiple cases. Those cases you were saying, they were situations where you were there was a judge, or either judges, or a judge and jury, there were witnesses on the stand, and you were the counsel asking the questions, presenting the case to that jury or to that judge.
Yes, I've been part of trial teams that do that work. Let's just be clear.
So it's not necessarily you.
It's not necessarily me, to be fair.
You're in the team.
But I've done it, and as a big firm litigator, for example, in this New Britain case, did it myself. Talked about the Charlevoix case, for example. Had a major role in that. On my feet, did the opening. It was a few years ago.
And was that one in New Britain as well?
No, that was in federal court in Bridgeport.
That was the federal court case, okay.
And so, just to be clear, you're part of a big team, and when you're part of a big team, often it's the most senior litigator, right?
Depending on the case,
who's right.
If it's a breach of contract, there's some guy who could be in LA. That's the #1 breach of contract attorney in the country.
Right.
Your team works on this for years. You're coming in for a trial. You're going to get that guy. You have a big company that pays a lot of money for these attorneys. You're going to get the best guy possible to bring through and be that lead counsel.
Or it's the senior most partner in our firm. So, for example, our firm just hired Deirdre Daley, the former United States attorney. Yeah. I'm sure that if I have the opportunity to practice with her, that someone's going to want her, on her feet doing the opening statement because she's Deirdre Daley. So that happens to hundreds. That's the way that hundreds of lawyers, trial lawyers in this state, practice every day in our major firms, from my firm, Findix and Hurling, to Day Pitney, to Robinson and Cole. There are hundreds of lawyers who are more than qualified because they're trial litigators who work as parts of teams and who've been parts of many, many, many trials and who are qualified to be Attorney General in this state and fit the definition of 10 years of active practice according to the statute and according to the Supreme Court. So again, feel extraordinarily confident because it's something I do every day. It's something that I do to pay the bills, and I'm not somebody who moonlights as a litigator. I don't practice some area under the area of law and then dabble as a litigator. I'm a full-time litigator at a major firm in the state with hundreds of clients and more than 400 matters and dozens of cases.
So to put this to bed, this blog post that was written saying basically you've only brought one case to verdict, right? One trial to verdict. You can stand here and you can say, look, there are multiple cases that I have been either on the team or on your own, usually with a team, where you were there with the judge, with the jury, and you were able to bring it all the way through verdict.
Yeah, but let me push back a little bit, George. I think Ryan is trying to rewrite the Supreme Court's decision in Bysewitz, and he doesn't get to do that. Last time I checked, Ryan McKean is not a Supreme Court justice. He's not a law professor. And the Bysewitz decision does not say a certain number of trials to verdict. And if you meet that standard, you somehow get to be Attorney General. That's not the law, period. The Bysewitz decision says some litigation experience. It says that 3 times. Yes. I have the Bysewitz decision right here.
But
it says that 3 times.
With some measure of experience in trying cases.
Right. But it doesn't say some exact quantum of trials to verdict, because that's not reality, right? The fact is, in a big firm practice, these cases take years and years to develop. They may go to trial, they may not. It may settle before trial, in the middle of trial, after trial. I'm sure Ryan has had many cases that settled in the middle of trial. Was that not a trial? Yeah. And the fact is that this is what the Attorney General does. Yeah. The Attorney General represents the state in a number of ways, but in major civil litigation, you know,
it's negotiations. It's
well, it's not just that, but it's
tobacco.
Tobacco that's a great example.
Major example, right?
Major example, multi-jurisdictional. Yeah. There's one, or 2 maybe attorneys general in a team of attorneys general who have the lead. And they litigate these cases for years and years and years. Motions to dismiss, motions for summary judgment, garnishments, attachments, depositions, all of that. And then at the end of it, they may not go to trial. You may get a settlement, for example, like with the National Mortgage Servicers, tens of millions of dollars, with RBS, hundreds of millions of dollars. Those settlements, maybe terminate the case at some point. But those are trials. Yes. Those are trials, and that's major litigation. That's what the Attorney General does. That's what I do for a living. I'm the only one running for Attorney General who does that for a living, period.
And so you can say, even if they question the total number or this or that there is more than one case that you've been with
absolutely.
To get through. If it's
absolutely.
Plural,
absolutely.
Can you give an idea, and I know you're going through a lot of cases for 20 years, an idea of, for what he's talking about there?
I cited 10 recent cases, at least 2 to verdict.
At least 2?
Yeah, at least.
So you got that.
Yeah.
And I think that's, so at this point, it's like, they always talk about, it's like trying to prove a negative. You can't prove a negative, right? And so the idea is how this has been kind of floating out there for 7 weeks. So I guess the final thing I just ask is, what do you want people to know? What do you want them to know about this question that some have raised? And what do you want to leave with people here today about your qualifications to be the Attorney General?
Look, I have taken a very close look at this question because I know what the state went through in 2010. And as the chairman of the Judiciary Committee with overall responsibility for our state's legal system and the statute, I take it very seriously. There's just no question under the statute that requires 10 years of active practice and under the Supreme Court's decision, which requires you to be a litigator for a living, representing clients, that I check all of those boxes in spades. What I would say is there have been a number of articles written, one by the Connecticut Post. It was a fact check, actually, in response to this smear campaign. And this is just an orchestrated smear campaign late in the campaign, and it's disappointing. And what I would say to Ryan McKean and to others, Ryan, again, as I said, is not a Supreme Court justice. He's not a law professor. He's not an acknowledged authority on this. He hasn't lived with this statute.
Probably a little bit of an authority on it.
He hasn't lived with this statute as much as I have as a lawmaker, and he doesn't get to redefine and rewrite the decision. That's not the standard. There's nothing in this decision. I challenge you, George, and anybody to show me any language in this decision that says X number of trials to verdict equals Attorney General. It just doesn't say that.
What it does say is that you need, like I said, is the one that S, right, is that the measure in trying cases, and you feel that you have the dockets, you have the cases and if we want to go through those cases you mentioned, we'll find transcripts, we'll find those things that will show that William Tong was involved
yes.
in different prospects of questioning witnesses, of making arguments to the jury,
and
we'll see that.
And writing briefs. I'll just be very
as a member of the team,
candid and upfront. Often the written work is more important than the courtroom work, but that's all trial work. And I think my firm and my clients value my work as a brief writer, and that is a huge piece of what lawyers and judges do, and have written tons of briefs. But yes, have been in a trial setting more than once, have taken cases to verdict more than once, and I just named off the top of my head, 8, 9, 10 cases in which the cases were heavily litigated with significant trial proceedings. And I just want to say again, it's really important to remember that trial is, it's a big term, and it includes all manner of contested proceedings, including motions to dismiss, motions for summary judgment, applications for prejudgment remedies, and trials to verdict. All of that is what litigators do. If you ask any lawyer in any courthouse, that's what they think of when they say, "Oh, I have trial this afternoon."
Yeah. They're going there. It's some portion of the trial. The verdict is one portion of it. The closing and opening arguments are one portion of it. Questioning the witnesses are, and it starts at deposition and
starts at depositions, goes to the major motions, goes to the motions in limine. All of those stages are contested. They can involve witnesses, significant briefing, and that's again what litigators do. And if you try to read a narrow reading into the Weissowitz decision that isn't there, you would disqualify hundreds upon hundreds of trial attorneys and litigators here in Connecticut at big firms like mine.
Tom, anything you can think of?
No, the only question I have is, it comes down to the definition of trial.
Yeah, in some ways, I guess that would be it.
Well,
and so you define the trial. So the idea is that the trial is going to start there at that first pretrial hearing.
Sure.
If it's a criminal case.
Wow. Yeah. That's not what the Attorney General does.
That's not what the Attorney Generals do. But in terms of, it starts with that first filing of intent to sue or intent to bring, whatever it may be.
Throughout a proceeding, there are throughout a case, there are tons of stops along the way that include significant trial practice. And so, for example, major commercial cases like mine, the motion to dismiss is the first big battle. Or a motion for summary judgment is a major battle. That can end the case. Those are contested proceedings in court. An application for a prejudgment remedy, like I said, is an important proceeding in court because that allows you to attach somebody's assets. That can be the whole ballgame.
Yeah.
And that can involve briefs and witnesses and oral argument and decisions and appeals. And all of that is trial practice. I've done years and years, 18 years total of that kind of work as my primary means of making a living. And you just don't get to redefine the practice of law or rewrite the Weissowitz decision because you have a political bone to pick or an agenda. And that's what I reject about this whole thing. This is about politics. It's not about the law. It's not about what the Supreme Court said in that decision. The Supreme Court was very clear.